Tennessee is now in session.
Thank you, Ms. Lindsay. On behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome Mr. Cole and Ms. Gentry to this oral argument, which we're holding via Zoom. It is being recorded and live streamed broadcast for public viewing to fulfill our obligation to hold open courts. We will conduct the hearing in the same fashion as if we were all together in the courtroom. Each of you have 15 minutes, and Mr. Cole has reserved some of his time for rebuttal. Unless there are any announcements, I'll ask Ms. Lindsay to call the case.
Eric Neff et al. Versus Dennis Wood et al.
Mr. Cole, the floor is yours.
Good afternoon, Your Honors. This is Jonathan Cole, along with my colleague, Austin Purvis, who is here with me in the room, but off camera. We represent the plaintiffs, appellants in this matter, Eric and Amy Neff. This case is about whether or not an agreement should be enforced according to its terms and whether or not it should apply equally to both parties to it. The agreement in question is an easement agreement that was entered into between the parties back in 1990. And actually, it was the predecessors in interest of the two parties that are actually before the court. The actual parties to the original agreement were a fellow named Jeff Jones and a family called the Owen heirs, the Owen family, that entered into an agreement in which they provided an egress and ingress agreement to provide access to their properties out in the Scottsboro or Bells Bend area, Davidson County. They each provided an equal portion of land. Each party provided 18 feet to provide a 36-foot wide strip of land that ran along what was Jeff Jones' property and would provide access and would terminate at the Owen heirs' property. The easement was not that long. It was about 1,440 feet, about 3/10 of a mile, and it provided the opportunities for the parties to use their property. Notably, there were no residents on either property at the time. The easement agreement had some particular provisions in it, one of which provided that any alterations, improvements, repairs, or maintenance had to be done jointly in terms of joint decisions between the parties, that there had to be a mutual decision about anything that would be undertaken on the easement itself. And the parties entered into that and was recorded in the Davidson County Register of Deeds office. The first party to use it to actually build a residence was Jeff Jones. And he built a residence a few years afterwards, and then shortly thereafter sold his residence to the Woods, who bought the property in 1995 and have lived there continuously since. The property, the Owen heirs property, was first sought to be developed or used by a fellow named Kenny Johnson, who'd purchased property from the Owen family. And he sought to build his home sometime in the early 2000s or mid 2000s. But he faced a roadblock. He sought to he didn't have utilities and access to utilities to his property. And so he sought to run that through the easement so he could build his residence on that property.
Excuse me, Mr. Cole. Ms. Gentry, could you mute your audio? We're getting feedback from what Mr. Cole is saying.
Yes, Your Honor.
Thank you. All right, please continue, Mr. Cole.
Thank you, Your Honor. And so Mr. Wood objected to Mr. Johnson's proposed use of the easement to use it for utilities, and in fact filed suit in the Davidson County Chancery Court seeking an injunction to preclude Mr. Johnson from engaging NES to construct a utility pole and to run utilities through that easement. They went to court, they tried the case, and Mr. Johnson was the one that prevailed at the trial court level. It was appealed to this court back in 2009. And in fact, two of the three judges on this panel today were sitting on that case. Judges Clement and Bennett considered the appeal of Mr. Wood. And Mr. Wood appealed to the court saying that there was nothing in the agreement requiring him to be reasonable in any way whatsoever. That the agreement had a specific provision that any decisions need to be mutual, joint decisions between the parties. The trial court had implemented a reasonableness standard and found that Mr. Johnson should prevail, and also found, though, that the parties weren't entitled to attorney's fees. This court, however, looked at the agreement, found specifically that it was unambiguous, and declared that the agreement should be enforced as written, as the parties intended, and as they entered into it back in 1990. And so even though Mr. Wood, there had been some discussion of utilities in the easement itself, that the provisions requiring joint decisions, mutual decisions between the parties prevail. And that was clear. And so the court said whether or not Mr. Wood was reasonable or not, that the court would apply it as written. Since it was unambiguous, the court reversed the decision of the trial court, found in favor of Mr. Wood, and also notably awarded him his attorney's fees, finding that the actions of Mr. Johnson required Mr. Wood to go forward and file this suit in court. And so therefore it sent it back to the trial court. Mr. Wood recovered his attorney's fees. Moving forward, Mr. Johnson ultimately sold his property to the Neffs, our clients, and they purchased some other properties, generally between 2012 and 2016, and began the process looking to build a home themselves. But yet again, when they first encountered the property, the first thing that they saw was Mr. Wood out there building a fence and creating a gate across the easement in order to restrict access. The Neffs were concerned about it, but in order to remain good neighbors, they wanted to open discussions with the Woods. And they met and they had a fairly agreeable time period discussing what they were planning to do about it, their vision for using the property. And Mr. Wood worked with them for some time until the point in which he asked to purchase their interest on the easement itself, buy them out. And for an extremely low amount of money, a low ball offer as the Neffs considered it, the Neffs decided not to surrender their interest in it, that it wasn't that they wanted to use that easement agreement. And that's part of the reason that they bought this property, was the access from Old Hickory Boulevard. And so they decided to proceed forward, but the things turned nasty between the parties. They started receiving a letter and communications from Mr. Wood, setting forth that he was demanding strict compliance with the terms of the easement agreement, that he wasn't going to allow them to use the easement at their own will. In fact, he started using language about our driveway, and he wasn't talking about the parties jointly. He was talking about him and his wife in terms of our driveway. He used that term several different times. And he indicated, and he mentioned that he'd already gone to court over this easement once. He prevailed in the Court of Appeals, and he's ready to go forward again. And he sent him a copy of that easement agreement, and again, demanded strict compliance. That's the term that he used. The Neffs were fine to do that. And so they replied that they would, but they're concerned about him building a fence and a gate across the easement and other violations of the easement agreement. They're willing to comply with the strict terms of it, but it needed to go both ways.
So was the fence line moved off the easement by the time the suit had been filed?
It was not, Your Honor.
And did it eventually get moved off the easement?
It eventually did after they filed suit.
And who bore the cost of that?
Mr. Wood did.
Okay. What about, was there proof that showed that the Woods cut down the tree or attached the electrical fencing to the NES post?
I believe that there was proof at trial was that there had been a tree cut down, yes, by the Woods. They claimed that they were required to do it, or NES wanted them to cut that down. The issue about the electric fencing was not proven at trial. However, there are a couple other concerns that were that came forth and uncontested at trial in terms of that the Woods had built a garden partially into the easement itself, and also
that garden remained at the time of trial.
I don't believe it did. I believe that got removed at some point as well.
What about the issue about the additional gravel filling in potholes or something? What was the issue? What was the problem or concern with that gravel? I mean, other than not getting your client's consent, were they harmed in any way otherwise by it?
Well, they're harmed in that the Woods expressed a basically possessory interest over the property. And so by them going forward and improving it in terms of the maintenance and repair and installing gravel and rock over time, that they exhibited that they had control, as they expressed. It was, their driveway, our driveway. And then also from that, the initial communication from Mr. Wood to the Neffs was that, that he might be willing to, he would grant access for some things, but not others. And they needed to consult with him. And so it's the possessory interest exhibited by the Woods that caused the Neffs the concern. But the most egregious thing is building the fence and the gate.
What about this idea about the land being used for hunting or the easement being used to give access for hunting? Was that family members of the Neffs, or was that third parties, or what was that situation?
I believe it includes both family members and other third parties. One thing
Were
we
the
would
Neffs charging for a
no, they were
hunting
not.
lease or license or anything like that?
No, they were not running a commercial hunting operation or anything to that manner. And so that's the concern that they had. And so they never received a response back from this letter that the Neffs sent to Mr. Wood outlining their concerns. They then retained me, a lawyer, to write a letter on their behalf, and I sent it to the Woods Council record from that 2009 case, and again received no response. So we've come to the court asking for several things. First of all, the attorney's fees. Neither party claimed money damages at the time, other than the fact that they had to file this action for, the Neffs had to file this action to protect their interests. And so we submit that the trial court, in finding that there was no basis to award attorney's fees, was an error, just as the court back in 2009 was as well. And this court was very explicit that when one party took an action that mandated or required the other one to take action to respond to it, that they were entitled to recover their attorney's fees. And this court sent it back in 2009 for Mr. Wood to recover his attorney's fees. Now we just have different players. And now Mr. Wood is the one who's caused that act, that caused the Neffs to come to court. And so therefore the Neffs are entitled to their attorney's fees, just as Mr. Wood was back in 2009.
Thank you, Mr. Cole. We'll hear from you on rebuttal. Ms. Gentry, you have the floor, and be sure to unmute.
Thank you. Good afternoon, Your Honors. And I do want to point out just preliminarily that I was under the impression that we were not supposed to give the link out to anyone. So the Woods are participating through the YouTube link rather than the Zoom link. I just want to fill in some holes here. This case is about the Neffs' steadfast refusal to comply with the easement agreement, the terms of which they want this court to strictly interpret and enforce, but apparently only when it comes to the Woods. As Mr. Cole pointed out, the Neffs and the Woods are adjoining landowners. They, together, the two strips of land that contributed to the easement tract, total a measure 36 feet wide and approximately 440 feet long. And within that easement tract is a driveway, and it has been the Woods' sole means of ingress and egress to their residents since they purchased the property in 1995. Paragraph 2 of the easement agreement, which the Neffs tend to gloss over, is that it does not provide egress and ingress to their property. It provides ingress and egress to residences located on the property. And if the Neffs ever build a residence or start to build a residence, then the driveway within the easement agreement, or excuse me, within the easement tract would be a secondary access to them. So if the court should decide that they no longer have any interest in the easement tract, then that would not cut off.
So has your client revoked this easement then?
That's what we're asking the court to do.
Well, I think that's a right under the easement. The court doesn't determine. I mean, do the proof show that your clients revoked the easement?
They haven't sent like a letter formally saying that we revoked this easement agreement. That's what our the Neffs, or excuse me, the Woods demand is in their counterclaim, because we believe that if the Woods simply send the Neffs a letter saying you can no longer use the easement agreement, or use the easement tract, that they would just continue to do so as they've done since they purchased the property that granted him the easement. Although the Neffs claim they want a strict interpretation of the easement agreement, and they want the court to bless their continued use of the easement for whatever purpose, regardless of not residence on the property, which they fully admit. although they have built several barns on the property, they just simply have not taken any meaningful steps to construct a residence on the property since acquiring that easement in 2015. Going to the point that Mr. Cole made about how the dispute arose when the Neff and the Woods did meet. The Neff said that they wanted to bring in horses through the easement tract. The Woods told them, well, they had learned through a previous lawsuit that the easement agreement was only supposed to be used for ingress and egress to a residence, and that they would allow them to bring in the horses like they wanted to, despite not having a residence on that one occasion. But they did send them a letter, and they did tell them in person, under the strict or explicit terms of the easement agreement, the easement tract is only supposed to be used for ingress and egress to a residence. Now, the Neff apparently became upset by that and sent a letter 1 week later saying, well, guess what? We too will require strict compliance. And for the first time ever, complained of purported violations of the easement agreement for placing crushed gravel in the easement, parking a utility trailer in the easement, placing a wooden fence in the easement, and also hanging electric fencing material on the utility poles.
Well, wouldn't
McBrayer
placing a wooden fence in the easement be a violation of the agreement?
Yes, Your Honor.
And so why wouldn't they be entitled to recover attorney's fees for that violation?
I'm glad you asked that.
Suit.
Well, they did not have to file suit. The suit arose between their first letter and actually filing suit was about 2.5 months.
Well, is there anything in the easement that requires them to give prior notice of a violation before filing suit?
No, there is not. But the case that the Ness rely on, the Wood case from 2009, the court found that the Woods were forced to file a lawsuit to prevent any action from occurring, to prevent NES from coming in and putting in utilities, running any utilities. So in effect, no violation had occurred yet, but they were forced to file a lawsuit to stop that action from occurring because NES had notified them that those utilities were going in. In this case, the action or violation had already happened. And just to point to Mr. Cole's statement that the most egregious is this fence and gate. Well, number one, the Woods didn't build the gate. The gate was there when they purchased it. The fence extended within 2 feet of the easement tract, but not into the driveway. So it did not affect anybody's ingress or egress to their property.
But I mean, it sounds like, both sides want us to interpret this easement strictly. And based on our prior interpretation in the Wood case, it seemed like that's the way we should proceed. So it sounds like in the strict interpretation, your clients did violate, but it also seems to me that under a strict interpretation, Mr. Cole's clients have violated here as well. And you've told me your clients have executed or exercised their right to revoke under this. So really, there's probably no easement at all here any longer.
You mean any easement for either party?
Yes. Because that's normally the result in a revocation.
Well, the Woods have only asked that the Neff use of the easement tract be.
Well, how does that work in a revocation of an easement agreement? Either revoked or not. You're saying it's only partially revoked. Is that your position?
Well, we want any interest they have in the easement agreement to be revoked, so that they no longer have.
Well, I understand that's what you want, but how's that provided for either under the terms of the agreement or the law?
Well, looking at the agreement, it does state that, let me see. if a party should violate this provision, then the other party, and this is paragraph 3 of the easement agreement, without further notice, revoke the grant of easement made herein in the terms of this agreement. To us, that seems that the Woods can, or whoever party violates provision, that their use of the easement can be revoked, but not that the easement be terminated. So given the inconsequential nature of these multiple unilateral improvements that the Neff complained of, the Woods reasonably believed that the Neffs have just simply filed suit to inconvenience them, to run up their attorney's fees, and really to attempt to leverage the Woods into permitting or expanding the use of the easement tract for more than what it was intended.
The Woods did make a technical violation of the easement agreement, didn't they? You're not supposed to improve it without consulting the other party.
True, but that was also cured. It was not cured before the case was filed, but it was cured shortly thereafter.
How do you cure that? Remove all the gravel?
No, I'm sorry, Your Honor. I thought you were talking about the fence. No, the fence was removed before.
I'm talking about the maintenance of the easement. The Woods.
Okay.
The Woods dumped rock, gravel, whatever, without consulting the Neffs. And that's a violation, isn't it?
Well, as we put in our brief, we believe there's a difference between maintenance and improvements. Under the common law, which I know the Neffs have argued that the parties contracted away their rights to common law, but they have provided no authority for that. And there's nothing in the easement agreement which states that the parties or that the easement agreement usurps the common law right to maintain easement tract for its intended purpose. And that's exactly what the Woods did, and what they've been doing since 1995 is maintaining the easement agreement by putting in gravel, or excuse me, the easement tract by putting in gravel, trimming branches, just to make it passable. Your Honors probably saw the photographs where UPS and FedEx had gotten stuck in the ditches as a result of the gravel being washed away. Even after the lawsuit was filed, they asked for the Neff's permission to add gravel to the holes in the driveway because of their daughter having surgery, which required that her physicians basically break her legs and reset them. Even the Neffs refused. So on the second day of trial, the court, upon its own initiative, entered an interim order stating that the Woods could make whatever reasonable repairs they needed to the maintenance to get it in passable condition, and that the Neffs would have to pay half of that. Also, the court in that interim order said that the Neffs had no right to tell, that the Woods did not have to run any maintenance by or whatever intended maintenance they intended to do under that interim order by the Neffs. Instead, the Woods simply had to make reasonable repairs so that it was passable, and that the Neffs had to pay half of that. We believe that the trial court properly found that the Neffs were not entitled to their attorney's fees because the Woods did not materially breach the terms of the easement agreement. The Neffs argue that they are entitled to their attorney's fees because the trial court concluded the Woods, in fact, breached the easement agreement. And that's not what the trial court said at all. The trial court said, yeah, there are some technical violations, but none of these rise to the level of a breach. And also the trial court found that their act in maintaining the easement tract was overwhelmingly constructive and protective of the party's interest and does not constitute a cognizable breach of the easement agreement. And again, I would just point to the fact that the Neff's reliance on the 2009 Wood case is is misplaced considering the fact that this court in that case found that the Woods were forced to file a lawsuit to stop any violation or breach from occurring. And in this case, any alleged violation, which the trial court found was not a material breach, had already occurred. We also believe that the trial court erred in allowing the Neff's additional time to begin constructing a residence on their property in order to continue using the easement agreement, rather than finding the Neff's had materially breached the terms of the agreement. The reasons for that, of course, are stated in our brief. But again, the easement agreement.
So how much time should they have to construct a residence?
We don't believe they should have any time to construct a residence, but in the event that this court determines that there has not been a breach by the Neff, then we think that the court's ruling as to the amount of time, the 180 days to begin constructing a residence, is proper.
I mean, I'm assuming your client can get access to their property without using the easement onto the Neff's property. Am I correct in that assumption?
I'm sorry, say that again.
I'm assuming your clients can access their property without using the Neff's easement at all. Is that correct?
The easement or the driveway within their easement tract is their sole means of getting to and from their residence. They don't have another driveway. However, if you're thinking in the terms of splitting the easement, so each party has their own 18 feet, I believe the driveway extends partially over the Woods 18 feet and partially over the Neff 18 feet, so that a new driveway would have to be constructed within solely the Woods is 18 inch width, or excuse me.
But they could, if we did that, they could access. I guess the answer to my question is yes. They have access to their property without use of the easement, just along their property alone.
If they had to construct a new driveway within just their 18 feet, you're correct.
I mean, it seems like to me when neighbors can't agree on anything, maybe they just, the agreement just needs to be dissolved altogether. All right, thank you.
And that's my time, Your Honors. Thank you.
Thank you, Ms. Gentry. We'll hear rebuttal from Mr. Cole. Be sure to unmute, Mr. Cole.
Thank you, Your Honor.
That's one of the jobs that we perform for no additional compensation. Just reminding council about their mute.
Very much appreciated. You think after a year we'd be used to all of it, but thank you. Just to hit a few points very briefly. My colleague, Ms. Gentry, has talked about that the trial court found that there wasn't a technical violation. That's really not actually correct. And I'll just read from the trial court's memorandum of opinion. The court found that the Woods never asked the Neffs for their agreement on items of repair and or maintenance. In doing so, the Woods maintained and repaired the easement tract in violation of the language of the easement agreement. The Woods also built a fence without securing approval of the Neffs that extended in part onto the easement tract. This fence was later moved to cure the violation. The court concludes that the Woods conduct occurred first. That, Your Honor, is in a nutshell. There's no discussion of technical, and I know my opposing counsel has talked a lot in our brief about materiality. There's no discussion of that. The court did refer to materiality, but used it and referred to it as it wasn't a cognizable breach of the agreement. However, it's very.
But if assuming we accept your argument as true and say that this was a breach and you're entitled to attorney's fees, that still wouldn't keep the Woods from exercising their right to revoke under the easement agreement, would it?
Well, if they had grounds to revoke it, and we submit
why isn't this hunting issue alone sufficient basis to revoke this easement?
Because the easement is intended to be used for ingress and egress and anything regarding it says the easements are not to be used to benefit or serve any non-residential use or activity on the Jones property or the Owen Ayers property. That's section 2 of the easement agreement, Your Honor. This is a rural or semi-rural area of the county. This isn't, downtown Nashville or 12 South or East Nashville, anything that we're talking about here. And frankly, in that area of town, hunting is permitted on your property. And so we submit under that term that the woods and the Neffs are entitled to use their property for any residential purpose that's allowed under the Metro Code. And yes, it's different in that area of the county than it is in the central core district. And so we submit, that regardless of the use of allowing hunters to use the property, which was not extensive, frankly, there's just a few instances of that, but just that is not a violation of it. And then also the ability to revoke it is restricted to just Section 3 of the agreement. And that just pertains to basically building only up to 2 residences on the property. And so therefore, if you built more than 2, if you built a subdivision or something like that, because it says in Section 3, if a party should violate this provision, then the other party may, without further notice, revoke the grant of easement made herein and the terms of this agreement. That's the only grounds for revocation. And so therefore, it's just based on basically if you built more than 2 residences on it. And there's obviously that's not the issue here between the parties.
Okay, just for the sake of argument, let's say I disagree with that and say the panel here decides that this agreement really should be revoked. How do your clients have access to this parcel?
Well, frankly, that if it's revoked, they would still have right, the half of the property that was given before. They have some access through Ashland City Highway. There's testimony at trial. If that's a lot more difficult, it's very hilly. Whereas this, the easement itself is on not a flat area, but it's just a gently rolling graduated hill, and the access from Ashland City Highway is a lot more difficult. And so my clients do have some, but it's a lot more restricted access.
Sounds like it would be a lot better for both sides if they could find a way to make this easement work, huh?
There's no doubt.
Yeah.
And then also, we ask that the restrictions put on by the trial court about building within a certain period of time, or that other people, the use of the easement should be taken off because that's not provided under the terms of the easement. So based on this, we submit that the court should continue to apply this easement strictly and reverse the trial court, grant us our attorney's fees, and remove the restrictions that have been imposed by the trial court. Thank you very much.
Thank you, Mr. Cole and Ms. Gentry, for your arguments. We will take this matter under advisement.
Thank you, Your Honors.
Thank you, Your Honors. Good afternoon.
Good afternoon. You are free to exit. Thank you.
Thank
This
you.
court stands adjourned.
Ms. Lindsay, I needed to tell you to unmute your microphone.
You did.